One app, many rights, but who is the legal owner? The campus carpooling application may look like one digital product. However, in intellectual property, it is made up of several legal elements. The source code, object code, user interface, app name, logo, route matching function, database, and technical modules can have different protection. Malaysian law may provide protection for the software code, graphics used on screen, written content, as well as the original arrangement of information in the database. The name of the app, logo, and slogan could be protected by trademark law. Patent law could protect a genuine technical invention behind the system if it is more than just an ordinary business method or mathematical algorithm. Industrial design and confidential information can also be relevant but not the primary focus of this question. Therefore, this presentation focuses on three main forms of protection, which are copyrights, trademarks, and patents. This protection will be analyzed individually to ensure the legal protection of each app component is clear. The argument is that Malaysian law gives useful protection to students, particularly through copyright and trademarks. However, the framework is only fully effective if the students deal with ownership and authorship clearly. If there is no written agreement, the law may protect the app against outsider but still expose the student team to internal disputes. The most important protection for the carpooling application is copyright because majority of the app starts with original expression. The Copyright Act 1987 protects literary and artistic works, and computer programs are included in the concept of literary works. Hence, the source code created by the students in Java, Python, Swift, or Kotlin, along with object code and written content of the app, may be subject to copyright protection if they are original and have been rendered in material form. In Malaysian case of Creative Purpose Sdn Bhd against Integrated Trans Corp Sdn Bhd, the court accepted that software programs can be protected by copyright where the defendant reproduce and distribute the plaintiff's software without consent. The case is useful for carpooling app. This is because it shows that if another person copies the student's login module, payment module, notification system, or ride booking code, then copyright can give direct remedy. However, copyright protects expression, not general ideas. Software is difficult because it contains both expressive code and functional behavior. Copyright should not become a monopoly over program functions. Applying these facts, the student cannot own the broad idea of a campus carpooling app. However, they can protect their actual code and creative implementation. Additionally, the user interface can also be protected by copyright, but it is not an unlimited protection. Original icons, app graphic, group illustration, button artwork, maps drawn by the team, and written instruction may be protected as artistic and literary works. Impeco wasn't Operation Limited Liability Company and Organization against Linetex Process Rubber Berhad. The court accepted that drawings have copyright protection if there is sufficient effort and originality. If the interface is visually distinctive, then this principle will be helpful for the student. However, common words like book write, cancel, or confirm payment are not likely to have protection because they are functional and common. This limitation is fair as other developers should be free to use normal interface language. The database raises copyright issue as well. A carpooling app can hold the title. This includes store user's name, student numbers, car particulars, ride history, pickup location, route preferences, and ratings. The original selection or arrangement of a database may be protected by copyright. However, copyright does not protect the factual facts themselves. It is dangerous to convert information itself into private property. In this app, the student may protect an original database schema or arrangement. However, they cannot protect factual information like student A traveled from hostel to faculty at 9 a.m. This approach protects creators' rights while ensuring the public can still use common ideas. Another issue is the use of third-party code. Many students' apps are based on open-source libraries, map APIs, or payment software development kits. Although students own the copyright in their own code, they still need to comply with the terms of any open-source license they use. If students use open-source code incorrectly, they may be liable for infringing their license or may be forced to disclose part of their own code depending on the license conditions. This issue shows that copyright is protective but also restrictive. Ownership and authorship is the biggest copyright risk. Under the Copyright Act 1987, the author is the first owner unless there's exception like employment or commission. In a university project, students are not employees, so the university does not own the student's work automatically. Therefore, the coder may own the backend code, the designer may own the icons, and the writer may own the app text. Authorship relies on creative contribution, but it can be complicated in collaborative works among students. Malaysian copyright law is fair as it recognizes the actual creator. However, copyright is not fully effective for a student team unless the team sign a written agreement assigning or licensing all copyright to the project. The second most crucial is trademark protection, which play a vital role for carpooling application for its brand identity and trust. Under Trademark Act 2019, a trademark protects signs capable of distinguishing the goods or services of one trader from another. For the students, the name of the app, the logo, slogan, and design of app icon should be protected through registration if the project has the chance of being used beyond its intended purposes. Trademark law protects a different interest from copyright. Copyright protects expression. Trademark protect commercial identity and prevent confusion. Trademarks reduce consumer search costs. When using the campus carpooling app, this is crucial because users must quickly identify the official carpooling app before providing personal data, payment information, and location information. App users often rely on visual signs and reputation to choose which service to use. Therefore, the app can be safer and have bigger commercial value if it has a distinctive name and logo. When registration is made under Trademark Act 2019, it gives stronger protection than unregistered use of a trademark. For example, let's say Group A register a unique name like UniRightX, they can prevent Group B from using a confusingly similar name with similar services. However, if Group A choose a descriptive name like University Carpool Malaysia, the protection will be weaker. This is because descriptive words should remain available to others. This point is supported because trademark law is to prevent deception rather than creating unnecessary control over common language. In McCurry Restaurant KL Sdn Bhd against McDonald Corporation case, it shows that public confusion is a crucial consideration. In this case, the federal court considered whether the public would be confused with the use of Mac. This case shows that similarity alone is not sufficient. The court looks at the overall impression and likelihood of deception. In Authors Expert Y Sdn Bhd against Noryani Adom and Anor, the federal court also confirmed the passing of elements of goodwill, misrepresentation, and damage. By applying this principle to carpooling app, if the student do not register their mark, they will need to prove goodwill before they rely on passing off. This can be a challenge at an early campus level as the app might not have a strong reputation yet. The branding issue is very crucial for safety purpose. Students may be tricked by a fake app with similar name. This includes students providing location details or payment information to an unauthorized platform. Therefore, trademark law not only protects businesses' value but also user confidence in the trademark. However, trademark law cannot prevent another team from developing an alternative carpooling app under a different name. That limitation fits the purpose because competition in campus mobility shouldn't be limited by brand registration. The ownership of the trademark must also be clearly established. If one student registers the mark and the other student develops the app, the registered owner can later control the brand. However, if the logo is designed by a different student, the registered trademark owner may own the copyright but not the copyright of the logo artwork. This demonstrates why copyright and trademarks rights should be coordinated through agreement. Overall, Malaysian trademark law provides sufficient protection for the name and reputation of the app. However, it does not protect the technology behind the app and does not remove the need for a written agreement defining ownership rights among the student's creators. In carpooling application, patent is the most uncertain form of protection. Under Patent Act 1983, an invention is patentable if it is new, involves an inventive step, and can be used in industry. Malaysian patent law also requires an invention to provide a technical solution to a technical problem. This is crucial because students might think that a right matching algorithm is automatically patentable, whereas ordinary algorithms, mathematical methods, and business schemes are hard to protect by patent. For instance, it might be commercially useful to have a formula that would match driver and passenger by time and pickup destination. However, this suggestion may still be an abstract method of organizing transport and might not be qualified for patent protection. Patent protection should be sensitive to the nature of the technology. There are situations where software businesses seek patents because copyright cannot protect functionality. However, in this student app, simple matching rules like matching students based on same travel time and pickup location are more likely to protect by keeping them confidential and also copyright protection for the written code rather than through a patent. A patent may only be applicable only if the student has created a genuine technical system. For example, if the app developed a technical method to verify users' location, a new way for the server to communicate with the device, or a new anti-fraud mechanism that enhances technical performance. With this new approach, the app has stronger ground for patent protection. There is warning that overly broad patents may prevent future innovation and development of new technologies. This means the student have patent protection for a specific technical contribution and not simply for the idea of creating a campus carpooling app. The case Spin Malaysia Sdn Bhd against Justru Marketing Sdn Bhd and Anor is relevant. The federal court held that inventing steps should be assessed by identifying the key technical contribution of the invention by looking at the patent claims and determine whether it would have been obvious to a skilled person. Patent protection is not for obvious improvement, but for genuine technical improvement that aren't obvious to skilled person in that field. Similarly, SKB Shuttle Manufacturing Sdn Bhd against Sengkong Shuttles Industry Sdn Bhd and Anor shows the importance of novelty and inventive step in patent validity. These cases shows that the student cannot simply describe the app as innovative. They must identify the precise patent claim and show that the technical solution is not obvious when compared with prior art. Patent ownership is also different from copyright. The inventor and applicant must be identified correctly. A dispute of patent rights may arise if student A invented the technical anti-fraud process and does not file the patent application, but student B later files the patent application alone. Patent protection is unsuitable for a small campus project as it is costly and slow. Furthermore, if the student discloses the invention during a university presentation or upload the code publicly before filing, it may affect the novelty. Thus, Malaysian patent law is fair because it reserves strong monopoly protection for genuine technical invention, but it is less practical for ordinary app features. Overall, Malaysian law is adequate as there are different rights to protect different parts of the app. Copyright protects code and creative interface, trademark protects the brand, and patent law only protects genuine technical invention. This division is fair since it prevents students from controlling the general idea of carpooling, but it will still protect their actual creative and technical efforts. However, the framework is not fully effective for informal student collaboration. The law assumes that creators, proprietors, and inventors can be identified clearly. In fact, student projects often involve overlapping contributions, informal discussion, and shared files. Therefore, the main weakness is not the absence of IP protection, but the uncertainty over ownership. A written collaboration agreement is crucial. It should specify the owner of the code, UI database, structure, trademark, patentable invention, and commercial rights. It should also be deal with profit sharing, withdrawal from the team, open source software usage, and university involvement. This agreement is also significant if the university provides funding, supervision, or incubation support. The student should check if the university has any ownership claim over intellectual property created by student. If the app attracts investors in the future, unclear ownership may reduce the app value. Therefore, legal protection is an essential element of preparing the app for commercial use. Malaysian IP law provides students with methods to protect their app, but the students must take accurate steps to manage their ownership and protection. This is why saying that one right is sufficient is not suitable. The students should compile copyright notices, private repositories, trademark registration, disclosure of invention, and a written collaboration agreement. These measures are not intended to introduce new legislation, but to make the existing Malaysian legislation to work in practice. Therefore, copyright, trademark, and patent protection should not be the only measure to test the effectiveness of law. It will also examine how this right can be owned, managed, and commercialized by the student team. In short, the carpooling application can be protected under Malaysian intellectual property law. However, there is no single IP right that can protect the entire app. The strongest protection is copyright as it protects software code, UI artwork, written content, and original database structure. Trademark law is also very useful for the app name, logo, and reputation. Patent law protection is narrower as it protects genuine technical invention only and not just an ordinary algorithms or business methods. The current Malaysian law is fair. This is because student does not have excessive monopoly over the general concept of campus carpooling service. It is also effective if the students register their trademark, ensure technical invention are confidential before trademark is registered, and document copyright ownership. However, if there is no written collaboration agreement, then different students may own different parts of the app. Thus, the best answer is that, in principle, Malaysian IP law provides adequate protection for the app. However, its practical effectiveness is determined by the student team on whether they establish clear ownership arrangement.